Good evening. Thank you for joining our live webinar. And today we shall deal with various questions relating to family law that are often posed to us, and many people sometimes get confused as to how to deal with these specific issues. So I have 10 questions on general aspects of family law. As I try to answer it for you, I will obviously try to unpack it so that it will make sense to you. And if you have that specific problem or dealing with a scenario similar to that, you would be in a better position to deal with it. Nonetheless, if you have a question, a live question, please feel free to post it on the Advocate Muhammad Abduroaf Facebook page and not on the Our Lawyer and the various other pages we have. We are streaming it live on various other platforms as well. But if you are live, feel free to pose a question and I will try my best to answer it for you. I'll keep an eye. However, if you are not interested in posing a question and just want to follow along, please feel free to do so. To begin, I have the first question and it's from the Western Cape. It goes as follows. I only have the father of my child's ID number. I do not know where he works or lives. Can I still claim maintenance for my 5-year-old child? Very popular question that I deal with. And it is a very sad question because it basically means that there is a minor child out there who is entitled to receive child maintenance, but unfortunately, that is not the case. So that's very sad and something which I obviously hope that we can try to limit and avoid from happening as much as possible. Now, the quick answer is yes, you can and you should still proceed with the child maintenance application. In terms of the Maintenance Act and the various amendments that came afterwards, it made it possible, or it made it more possible recently, for you now to obtain the whereabouts of the other parent when it comes to claiming maintenance and at the same time when it comes to enforcing a maintenance order. Now, each maintenance court has a maintenance investigator, or they should have one, and they have resources as well. With today's modern ways of locating people, one example for argument's sake would be if you register a SIM card, you have to indicate they want proof of address. And if you applied for a loan somewhere, of course you will, provide your most recent address. And if you work and so on, SARS, bank account, the maintenance officer, using the various resources he or she may have, will use the ID number in this specific scenario and find out the whereabouts of this person. They might do an ITC check, a credit check, and various other checks. They might go to Vodacom, MTN, Telcom, and verify whether or not there is any person who is using this specific ID number on the database. And I'm certain they will find that. Everybody has a cell phone. And in doing so, they will obtain the telephone number and they'll phone this person and say, we have a complaint for non-compliance or complaint of you not paying child maintenance or supporting a minor child. We would like to institute an inquiry. We're not saying that you should pay or shouldn't pay. That's besides the point. The inquiry should first take place. And then the court will obviously make a determination on what amount should be paid. But they will obviously follow up on that. And there are various other ways of determining where a person resides. Things are so public these days. And if you have the person's cell phone number only, you can play the reverse. You can contact Vodacom, MTN, and so on, and ask them where is this person residing, what legal information did he provide. There are various ways. The bottom line, what I'm saying here is you should still proceed to the local maintenance court wherever you reside. Approach them, tell them I have the following details. Please institute an inquiry. They will do it, and they will do whatever they can with their resources to find out where the other party is residing. So that answers that specific question, number one. Let's move to the second question from KwaZulu Natal. The question is as follows. I want to divorce my husband, but he lives in the USA. Is it possible? Where do I start? I live in KZN. Okay, so that's a question from KZN. Now, in terms of South African law, in order for you to divorce your spouse, in simple terms, one of the spouses has to live in South Africa or within the court's jurisdiction. So if you live in Cape Town and your spouse lives overseas, and you lived in Cape Town for quite some time, and your spouse lives overseas, you can institute divorce proceedings in Cape Town court. But you cannot institute divorce proceedings in Johannesburg court because you don't live in that court's jurisdiction. So, seeing that you are living in KwaZulu Natal, you can proceed to your local family court or to the High Court, and you can institute divorce proceedings from that specific court. So that's possible. Now, when it comes to the issue as to how do you serve the divorce papers on the other party, now there is something called the dictal citation, where you serve court processes, court documents like a summons in this case, on the other party via or not via the sheriff of the court. The normal way of serving a summons on somebody would be to take it to the sheriff. In South Africa, the sheriff will go to the person's house or work, wherever the person is, and serve the summons on that specific person. In this specific case, unfortunately, the parties overseas will have to make use of other means. You'll approach the court, or your attorney or your advocate will do so, and you will ask the court, can I serve this documentation, the summons, on the other party via email? That's one way of doing it. Or via an attorney that side. That's another way. Via WhatsApp and whatever other means there is to ensure that the other party receives the specific summons. If the court is convinced that there is no other way of serving the summons on the other party because the person is overseas. And once the court authorizes that, you follow that procedure, your attorney or somebody will email it to the other side. The court will be convinced that the other party at least received it. I think that would be important. And after that has happened, you proceed with the divorce proceedings. The case continues. More than likely, the other party would get an attorney locally to defend the divorce, or they might enter into some settlement agreement, etc. So that is possible. So remember the word edictal citation. You can Google it. There should be some articles and information regarding that. The third question from the Western Cape. How do I apply for maintenance against my parents who are both unemployed? I am 21 years old and studying. My parents have assets. Very important thing to note, it does not mean someone is unemployed that you cannot claim child maintenance or support from that specific person. If that was a requirement, then I would imagine people will decide to resign from their jobs in order not to pay maintenance. I know some people do that, but we look at assets as well. Very important. The person might have investments. The person might have other means of income. It's possible. And therefore, you do not look at employment per se as a sole requirement. It is possible for somebody to own 10 houses, 10 cars, loads of investments, but not working, just sitting back and enjoying the money. I'm not saying this is the applicable in this specific case, but it is possible to proceed against somebody for maintenance if the person is unemployed, but the person has assets. And here the person says, my parents have assets. Now, interesting to note, this specific questioner is 21 years old and adult already. It is possible for you to claim maintenance from your parents even though you are an adult already. And it should happen, and it happens often where a child is 18 years old in matric or grade 11, and the child requires maintenance, although the child is an adult already. but the child is not self-supporting, the child is still busy with school, still studying, that specific child can proceed to the maintenance court. So, regarding question number 3 from the Western Cape, please approach the maintenance court, your local maintenance court, and apply for child maintenance against your parents. And they will make a determination. Maybe they should pay, maybe they should not. I do not know, but an inquiry will have to be done. So that's our third question. Okay, we're moving now back to the Eastern Cape. Question number 4. My child's father does not support my child at all. I have a job offer in Canada and want to take it. However, he will not consent to the relocation. What can I do? Yeah, this is one of those interesting ones whereby a parent might not be too much involved in a child's life, but because the parent is the biological parent, he or she might be a bit difficult, sometimes legitimately so, and other times unreasonably so. But nonetheless, in this specific scenario, the mother wants to go overseas because of a job offer. The father is not supporting the minor child at all, and the mother, I would presume, believes it would be best for the minor child to go with her. She can't leave the child behind, etc. Now, if the father, I would presume, has parental rights and responsibilities, and let's say presume it does have so, because even if it does not necessarily have that, the border control and various people might say he has it, and there's a dispute, and there's an issue, and you'll have problems going forward, because he has one version and you have another version. Unfortunately, you would have to approach court, but the court, as upper guardian of all minor children, can say, you know, father, you are being unreasonable. The minor child would have a better life in Canada. The mother is going there for work purposes. Maybe the father is unemployed, they cannot afford to maintain the minor child, and so on. And the court might make a determination, considering what is in the child's best interest, to allow you to relocate to Canada without the father's consent. It happens quite often. Each case is different, of course, but the court would have to determine what is best for the minor child under these circumstances. If it is best for the minor child to remain in South Africa, but with limited financial support, um, the court would, of course, say the child should remain here. But if the court believes that it would be better for the minor child to move with a parent overseas, better schooling, better education, better medical facilities, resources, and so on, the court would, of course, make such a order that the father's consent is not required. So each case is different. However, we focus on what is best for the minor child. Question number 5, we're getting somewhere. From Gauteng, my two nieces are living with me. So this is not a parent. Their parents neglected them since they were young. What can I do to become the legal guardian? Okay, to backtrack a few steps. Only parents have parental rights and responsibilities over minor children, not third parties. Third parties includes grandparents, aunts and uncles, and so on. However, it is possible, if it is in a minor child's best interest, for those specific persons, these third parties, to acquire parental rights and responsibilities over minor children. It is possible the court can confer that upon the assign it, sorry, upon these specific parents. Therefore, should it be in the minor child's best interest for you to become a legal guardian over the minor children, the court will make such an order. And why would you want to become a legal guardian over the minor children? Very important. Number one is, should the minor children apply for schools, they might ask who is the legal guardian of the minor children. Problems could arise. Should the minor children apply for a passport? Should the minor child go to a doctor, medical aid, and so on? These are serious issues that the guardian has to consent. But in my scenario, in my question, the parents have neglected the minor children. And the aunt is looking after, or the uncle, I presume. I presume it's an aunt. But this specific aunt or uncle is looking after these minor children. But these problems that may arise regarding guardianship issues. The daycare will say, ma'am, your surname is A, but his kids' surnames are B. You can't be the parent of these specific kids. Where the birth certificate? Problems may arise. I have made many of these type of applications, and in my professional view, if the facts are there, the court would not hesitate at all to assign parental responsibilities and rights to the specific aunt or uncle over the minor children. So you'll have to approach a court, and the court can give you that authority. Question number 6 from the Western Cape. I think we've moved further up a bit. Typo. There we are. Is it possible to enter into a parenting plan with the other parent when the other parent is not willing to sign? Now, something to note, a parenting plan is an agreement. So basic legal principles are an agreement is where both parties agree. Two parties have to agree. So you can't enter into an agreement if one party is not happy with that agreement or not willing to sign. So both parties will have to agree to that. Therefore, from a legal point of view, it is not possible to enter into a parenting plan with other parties willing to agree. Now, but we need an answer. We have a problem here. We need to deal with the care and contact arrangements. You know, what happens to the child from Monday to Friday, from Saturday to Sunday, or from the first of the year till the end of the year. Usually, a parenting plan will deal with all these specific issues: school holidays, birthdays, Father's Day, Mother's Day, the child's birthday, religious days, etc. These are important things that are dealt with in a parenting plan. But if the other parent is not willing to sign, the court can make an order. The court can make an order. You know what? I've considered everything. I've considered what the one parent has said. I've considered what the other parent has said after. I've considered what the experts have said, maybe the family advocate, maybe a social worker. And I believe this is the best way to resolve this matter. Holidays will be dealt this way. Religious days will be dealt this way. The kids will reside with the parent during these times and with the other parents during those times. So the court can make a final determination. More than likely, the court might make a final determination which is in line with the parenting plan which the other party does not want to sign. However, the court would obviously have to now determine whether or not the forced order, the forced arrangement, I would say, is in the child's best interest. So that's my answer to question number 6. And now we can go to question number 7. How do I divorce my spouse if he does not want to sign the divorce papers? Now, many people are under the false impression that in order for you to divorce your spouse, they have to sign. Now, that's not how the law works. If the other party signs the divorce papers, for example, the consent paper and the parenting plan, if there are minor children involved, the divorce can be resolved much quicker. Fast, because it's an unopposed divorce. Basically, all that happens after that is you apply for a court date, you obtain a court date, you have the family advocate endorse the consent paper, and a few weeks, 1 to 2 months, you get divorced. If, however, the other party is not willing to sign the settlement agreement which you prepared, now presume you prepared that settlement agreement, and he or she has full right to say, I'm not happy with the terms of the settlement agreement. I'm not happy with it. I do not think it's fair, just, and equitable, and therefore I am opposing it. That could be his reasons. It might be valid, it might not be valid. But nonetheless, whatever his reasons are, he's full right to oppose it, he or she. If he or she does oppose it, of course, the divorce has to go its normal course, whereby you will plead, there might be a counterclaim, etc. There will be case management proceedings that might take place, there will be a discovery that will take place, etc. And there will be a trial date in due course, in a few months' time. Could be a year, could be 2 years, could be a few months, depending upon the court and the circumstances. And then on that date, the court will listen to what the plaintiff had to say, could be the wife, could be the husband, and the defendant has to say, and maybe other experts as well. And then the court would make a final decision regarding the divorce. So the long and the short of the matter is you cannot necessarily force the other party to sign the divorce papers if they do not want to sign it. However, at the end of the day, the court would obviously have to be fair and just and apply, good reasoning as to what decision the court makes. Okay, we're coming towards the end of this questions that have been posed. I do not see any questions on the live, which is a good thing in some extent because it means everybody watching is learning and enjoying yourself and they're not having any questions. Question number 8. Can my son live with me even though he is 17? Can he choose? His mother does not want him to stay with me. 17 years old, you're still a minor. You do not make the decision. Parents have to make a decision for the minor child. If the child is 17 and turning 18 in a few weeks' time, I think it's basically this academic because when he turns 18 or she turns 18, automatically they're adults and they can decide what they want to do with their lives. Of course, we expect them to make reasonable and rational decisions and not decide just to leave the house and go live with friends and throw their life away. But in a serious scenario, the child cannot necessarily decide on their own. The parents would have to decide. But what if one parent wants the minor child to live with him or her, and the minor child wants to live with him and her? Now, these are the difficult questions that comes about. Is a divorce order, is an order stipulating that the one parent is the custodian parent of the minor child, and so on. If there is no such agreement and the child has always been living with the one parent, I would advise that you resolve this matter by taking it to the court, to the children's court, or to some legal person if the parties cannot resolve it. Alternatively, take it to a social worker, and the social worker or psychologist can try to resolve this issue for you. After consulting with the minor child, looking at the parent's circumstances, what is best for the minor child under these circumstances. Because 17 years old could be an age where the child could be in matric or grade 11, an important age in a child's life. And we do not necessarily want to disrupt the child's routine, etc. Just because, for argument's sake, the other parent now has a swimming pool and now the child wants to go live there, or the other parent bought a house and things will be fun and games on that side. So the reasons why the child wants to also move to another parent are very important. So the long and the short of the matter is the child cannot decide, the parents would have to decide. If the parents cannot come to an agreement, they ultimately will have to go to the court to resolve the issue. Question number 9. What amount of maintenance should one pay for a 17-year-old child? Now, it's very important to note the law does not stipulate any amount of child maintenance for any specific child or age. In the sense of one child may have certain expenditure, schools might be a bit more expensive in a different province, extramural standard of living, and so on, where a different child might have a more modest type of lifestyle. And that's normal and that's very good for that specific family. So if I say, for argument's sake, a child of 15 years old costs child maintenance costs, for argument's sake, 5,000 per month, where another child in a different province, a different area, different family background, father might be a minister, mother might be a medical surgeon, whatever the case may be, for him, 5,000 will be too little. Maybe 15, 20, 30,000 will be more reasonable for that specific child. So there is no amount of maintenance specific to a specific child. That doesn't work that way. However, what you do is you look at the parents' income, the child's needs, child expenditure, the standard of living, and so on. And then based upon that, you come to a determination what to be a fair amount of maintenance to pay or for a parent to pay. I hope that answers your question where that is concerned. And now we are on the last question, question number 10. Number how 10. Why do I need to why do I need the consent of the other parent to change my child's surname to mine? Okay, so this is now obviously a difficult one to answer because I do not know are we dealing with the mother or the father. But the long and the short of the matter is a child's surname is very important towards the child. The child is identified by that surname, his friends knows his surname as being X, Y, and Z. And you cannot, as a parent, just go and say, I would like to change the child's surname to my surname because I would prefer it that way, despite the child having the other parent's surname for the last 15 years of the child's life. Both parents need to consent to it. If the parents cannot come to an agreement regarding the surname change, of course the matter will have to go to court, and the court will have to determine what is in a minor child's best interest. So the bottom line is for a parent to decide to change a child's surname to a different surname, despite the child having a surname all his life or her life, would not be in a child's best interest. Thank you very much for partaking. For all the people that are viewing this webinar live, it's much appreciated. And I hope that you had a good learn from these 10 questions. And I hope to see you online again soon. Thank you very much.